Welcome to the webinar. This is a part 2 with Robert Michael, and the webinar we did a little over a week and a half ago, I guess. He did a high-speed interview or overview of his new website and the processes associated with it, and where he's taking it in order to help people live in the private, move to the private, and take control of the game that we've been controlled by, and ultimately achieve a level of freedom that I think many people want to achieve. So it's great that he's moved everything that his work has brought him to onto the website. He's got training going up, and what he mentioned last time he was on the call was that he had a court case. Now, he did, it must have been the summertime when he was on a road trip, and he decided that when he got pulled over by the police that he was going to use it as a test case and use himself as a test case. Robert Michael is one of these guys who walks his talk, and it's always impressive when you see somebody willing to walk their talk, and he definitely does that. And he decided that he was going to have some experiences with the police on the side of the road. He had a group of them there. He posted the video of it so you can see exactly what he did and how he did it. It went on for quite some time before they decided to arrest him. He's got some charges, and he went and he handled that, or at least some early stages of that process. And he's going to give us an update on that along with anything else. So a big part of living in the private is understanding how to interface with the public agents that are out there. And if they do come to you, how to handle it. And if they do take you to task by charging you with something in some way, how to handle it. Because living free does not mean that you are going to be allowed to live free once you put your sign up, so to speak. You're going to be tested, and you better be ready to pass those tests. And so that's part of what the training is, and part of what Robert Michael's personal firsthand walk in his talk experience is all about. So welcome again, Robert Michael. Thank you for coming on and having a talk with us and telling us what's going on. And I'm looking forward to hearing what you have to say tonight.
Thank you, JD. As I mentioned last time, JD and I have been friends for quite some years. And yes, I definitely have had many experiences walking into court, dealing with officers in different situations and things like that. So as he mentioned, last year, I got myself pulled over. And just to preface this, like, I am definitely familiar with the right to travel, that you don't need a driver's license and all that kind of stuff. That was not my point. My point was not to show that, oh, I have a right to travel. My point was to show you guys are functioning in a corporate capacity to collect revenues. This isn't about anything else. And in order for you to collect those revenues, you're going to have to run that through the Social Security account. And in order to run that through the Social Security account, you're going to need name, address, and birth date, because that's what ties back to the Social Security account, which all of this is running that way. This is all about, you know, it's all about money, and it's all about insurance, and insurance is the social insurance number, Social Security number, Social Security account, and all that stuff. So when I got pulled over, what was going through my mind is, we're going to set something up here, and we're not going to try to have this officer let me go. We're not going to try to discharge this case on a right to travel with some magical paperwork. No, we're actually going to expand this. We're going to allow this thing to mushroom up. We're going to allow it to, you know, grow. We're going to allow them to do these things to me, whatever these things are, whether it's an arrest, you know, court hearings, whatever. And I was saying this last year, and we've come to that point. So going to court for most people is super scary. Okay, let's face it. Anybody that's ever been to court, it's super intimidating, and that's the model, right? They want you to be scared. They want you to fear their authority. When really, it's all smoke and mirrors. It's just they have the guns, and they force us into these courts, which are, yes, in my opinion, they're admiralty, commercial courts, all that. They're not courts of law. They're courts of commerce. And I get all that because I've been through this many, many times. So what I am doing is I'm using this experience to expand as something I can show other people and teach them with along the way, and B, so we can really push the envelope with exposure on certain things. And I'll tell you how we're going to do that as we go forward. But one of the main things I want people to understand is how to feel in alignment with what you're doing from a spiritual perspective, right? I'm not here to fight these guys. So when I get pulled over on the side of the road, I don't argue. I'm not, or I shouldn't say I don't argue. I question, and I'm kind to them. And when they're putting me in handcuffs, I'm smiling. It's okay, guys. I get it. You know, I forgive you for you know not what you do. Trust me, you don't. It's clear. You have no idea what you're doing. That mindset, I'm not in it to win or lose. I'm only in it to prove the next thing, bring more to light, bring more to light, bring more to light, especially with something as minuscule as a traffic violation. So this traffic violation turned into a criminal misdemeanor, which is the charge that they're trying to throw on me is obstructing an officer, a law enforcement officer in the course of his official duties, right? Very minor stuff, which is great because at the end of the day, no matter what happens, like there's not a big sentence hanging over my head, okay? So I get to really experiment with this. But again, I'm in alignment with peace with these guys. I'm not at war with them. I know they don't understand this stuff. That's the point. The point is to show, like, look, you guys don't even understand what you're doing. You're just merely imposing and enforcing corporate policy. That's not law. That's corporate policy, right? We all know this. So thankfully, God has put me through this journey of education and studying and learning and having the guts to, throw this back on them in a way that it's on the tip of my tongue of how to handle myself all the time. So the way I handled this particular incident was with peace, honor, dignity, respect, all right? Very important to stay in alignment with that. We're not fighting. We're defending ourselves, sure, but we're not the ones, reaching for their throats. We're letting it be shown that they're constantly reaching for my throat, and I'm putting my shield up saying, no, sorry, no, you're not going to do that. No, not there either. Nope, sorry, you're not doing that. Okay, so when the officer pulled me over, my thing was, look, am I under arrest? No. Am I free to go? No. Then this to me is an investigation to extract information from me that you're going to then use to charge the Social Security account or apply those charges to the organization that carries the name similar to mine, okay? Which some people call it a straw man. I like to just simply say it's a legal person. I don't like to get into straw man language or anything. So that's what you guys are doing. You don't understand that, but I do. So therefore, I'm not going to give you that information. And I feel like this is an investigation because you said I'm not arrested, but yet I'm not free to go, which means my information is voluntary. And without an attorney, I don't have to give you that information. So I don't have counsel here on the side of the road, so I'm not going to give you that information. Now, in this interaction, the police say, well, do you have a license? Sure, I do have a license. I'm not afraid of having a license, right? People say, oh, you can't have a license. You're in the system. Right? I'm never in the system. You're never in the system. And your family, friends, neighbors, people, they're not in the system. It's impossible. Because if I was in the system, I would not be sitting here with a lamp behind me talking to you on a screen, right? It's that simple. It really is conceptually that simple. I'm not in the system. The information that is related to me is in the system. So again, we're just doing business. We're just doing business. We're figuring out this is how we do business, okay? You want to license the right to actually travel? Fine. I signed my license without prejudice, so I reserve my rights on that agreement. Now, they're stopping a lot of people from doing that, but at the time I had this license, I was able to do that. Very clear, without prejudice is on the signature line, period. These guys don't know this. I'm not even going to bring that up to them. So when the officer says, hey, do you have a license? I go, sure, here you go. Here's the license. I held it up to the window. He didn't say, can I inspect the license? He didn't say that. He didn't say, can you give the license to me? He said, do you have one? Yes, right here. Then I put it down. because I don't want him to extract the information off of it that he's going to use to impose the charges through the Social Security account. In my mind, what I'm telling him is I'm protecting a federal account, okay? Because I don't think the feds want some unknown organization charging it. Maybe you are known to them. I don't know. We haven't established that yet. So that account needs to be protected, right? Because I'm the holder of the account. All right, you're the holder, that makes you the trustee. So anyway, we get into this on the side of the road. 2 hours goes by, 6 cops standing outside threatening to break the window, which they couldn't because I kept stopping them. I wouldn't do that. I'd call your superior. Before you break that window, we have all this recorded on video. Before you break that window, you need to call your superior. So they did. But the superior wouldn't come out. He got on the phone, so they gave me the phone. And the superior admits to me, he said, look, you're right. We don't need a license, actually. We don't need to see that. The only thing we do need is your name, birth date, and address. All the things that tie you back into the system, you know, into that information so that they can tap that account, right? Great. Thank you, officer. Hang up the phone. Did you hear that, guys? Outside the window, I hand them the phone back. Yeah, we heard that. Great. Here you go. So then they said, what's your name? I said, Robert Michael. Is Michael your last name? Yes. It's the last name I was given. That's the truth. You don't have a first, middle, and last name. That only belongs to things. And if we read American jurisprudence, which I keep on the wall, or Corpus Juris Secundum, which I don't have a copy of, but you can get that at the law library, or whatever law encyclopedias you have in your country, and you research names, it doesn't talk about first, middle, and last. It only talks about given and family. So I gave them my first and last name. Robert Michael. My parents gave me the name Robert. Then the last name they gave me was Michael. You didn't ask for my surname. You asked for my name. I gave you my name. And when you asked me if Michael was my last name, I said yes, because it's the last name I was given. Do you see what's going on here? I've not lied to them one time. I've not lied to them at all. I've not obstructed anything. It's not my fault if you're not clear in your questions. Okay. We have a misunderstanding here. When were you born? I said, well, it was sometime, or what's your birthday? Well, it happened sometime in August in the year 1975, but I can't give you the exact day because that information comes from my parents and I'm not a witness to that. So I don't have firsthand knowledge of that. And for me to tell you that it actually happened that day is not, may not be accurate. I'm just telling you the truth. So of course they throw their hands up. Oh, all right, that's it. And they call another superior who comes, breaks the window without any questions, didn't answer, didn't give me his name or badge number, which they have to do. It's all on camera, right? Didn't do it, broke the window. And then of course the guys want to grab me, you know, rough and throw me out. Oh, wait a minute, I'm getting out. You don't have to do any of that. I didn't say I wasn't going to get out of the car. Your guy clearly just damaged someone else's property. It wasn't even my car, it was my girlfriend's. Just damaged some other property. I'll get out. I can see you're being hostile. Got out. You know, they immediately stopped, you know, manhandling me, and because they saw that I was just like, let my arms down and stood out. I was like, sure, you know, do what you got to do. Let them cuff me, put me in the car. Anyway, take me to jail. They got 48 hours to find a charge. When I get there, a lot of this is about asking the right questions, right? Knowing what you're doing going into the situation is very, very important. I had a plan. My plan was to stand my ground that my understanding is you are a corporate entity collecting information to charge an account, and this is all business. There is no laws being broken and there is no crime, although that's what you guys see. I'm sorry that that's your understanding. My understanding is different. Based on the extrinsic evidence surrounding this matter, I have the ability and the right to understand it this way because you guys aren't clear. Everything you do is ambiguous and what's the other word? Presumptive. If you want to look something up, look up the legal definition of ambiguity, okay? There's two forms of ambiguity. There's latent and patent, or latent and patent, okay? A latent ambiguity, it means that there are words that seem to be, you know, what any normal man would believe this word means, okay? But there's surrounding evidence that makes it obscure, so there's an ambiguity there. And if that happens in a contract situation, the one who writes or is assuming there's a contract has the weaker position. In other words, I'm in a stronger position because I can't understand what this means because it's ambiguous. Okay, so I'm going on this whole premise. They bring me into the station. I'm asking questions because I want my understanding to be clear. So when they go to book me, right? Oh, we need your fingerprints. We can't do that, man. You know, I'm sorry. I'm a man of God. I can't give you any of my property like that. Real friendly. And the guy's like, I understand. I said, well, let me ask you this, sir. I said, these fingerprints and everything, does that get somehow incorporated or tied into my social security number? And he looks at me very frank, very matter of fact, and innocently like, well, yeah, of course. That's what he says. Yes, of course. Great. That's all I needed to know. Your camera's running. Your audio good. Okay. Tied to social security. Thank you. Right. Now you furthered my understanding. So fine. You do what you got to do, but I don't consent to it. But I understand you're not going to let me out of here unless I do this. And so I'm under threat and duress. So of course I sign. Now when I sign things, it's just without prejudice, the words, okay? Vi coactus, V-I-C. It almost looks like vi cactus with an O in it. C-O-A-T-U-S. That means under threat and duress in Latin. Vi coactus. You can even put initials V.C. Okay, without prejudice. I'm letting them know I'm reserving my rights and I'm under threat and duress here. Okay, fine. Because you guys are going to continue doing what you're doing because you're brainwashed. You don't know any better. Right? You got the guns. I'm the sovereign citizen guy, which they tried to say. And I said, no, we need to correct that right now. I'm an American. I'm not a sovereign citizen. I know you get sovereign citizens in here that argue with you guys and tell you the laws don't apply to them and all. That's not me. I'm different than that. Okay. I understand what the law is, and we have a misunderstanding. And we'll take that up with the court because clearly you guys, that's not why you're here. You're just here to enforce that misunderstanding. So we go through it. Of course, I'm held for 48 hours. At the 45th hour, they call me over to the bond hearing. All right. Judge gives me excessive bond. I call her out on several things. Very calm, you know. Sure. Okay. First thing I need to clear up is my name is not, Robert Michael Doe. I'm here as the general executor for that estate. You've got the wrong person based on the names. I'm sorry, but that's how it is. So please correct your records. I'm not pro se. I'm sui juris improper, meaning I'm here in my own right, in my proper person, not the person you assume. Just want that on the record. Is that on the record, Judge? Yes, it is. Thank you. Let's proceed. Go ahead. And of course, they start going through their bond stuff. I said, well, I got a question about the bond. Where does this bond reside? What else did I ask him? I said, I reserve my rights on that contract. And she said, well, it's not a contract. I said, well, yeah, it is a contract. I said, all bonds are contracts. I said, it's a financial instrument. Oh, no, it's not financial. Yes, it is a financial instrument. You can negotiate that bond. It's a financial instrument. Oh, I'm sorry, sir, but that's not it. So anyway, she's going on and on. And then I caught her in something else, telling her, I said, look, I don't consent to this. I don't consent to any of these proceedings. And of course she says, well, oh, that's what it was. They gave me excessive bond. You can't leave the state. I said, no. I don't have a criminal record. Remember, if you have a past criminal record, yes, that's going to hurt you because they're going to use it against you. I don't have one. And I knew that because I've already been through this in a prior criminal situation that I discharged with my birth certificate. And they tried to, or that was one of my saving graces was I didn't have a prior criminal record. Well, I still don't because even that case was discharged and dismissed. So I said, I don't have any criminal records. She goes, well, it doesn't matter because I don't have anything on file. Sorry, but I don't have anything on file that you're not a criminal. I said, well, I'm not a criminal and I haven't done anything criminal. Well, I don't have it on the record. So I'm giving you a bond that you have to stay in the state of Kansas. Now I live in Arizona, some 700 miles away. This is the state of Kansas. So I said, well, I disagree with that. I've got a 15-year-old son at home and nobody to take care of him. I don't have any family there. I'm not from that state and we're new there and I don't know a lot of people. And my son is staying with someone right now, but he can't stay for 3-4 weeks till the next hearing. That's ridiculous. Well, you should have thought of that before you committed a crime. Oh, thank you. I said, so you just admitted that there's no jury here. There's no anything. You literally just convicted me of a crime. And she started, you know, I caught her in a bunch of stuff. She was stumbling, didn't know what to say, you know. So you really have to like listen to what they're saying to you, because they're so ignorant of law that they will trip themselves up and step in landmines constantly stepping in landmines. But if you don't know enough, you're not going to see that. All you're seeing is red and, you know, anger and screw you, you can't do this to me. And that's what they want. So I stay calm, listen, counter, ask questions, wait for the next thing, right? Secure myself with whatever agreements are going on, because this is all about contract and agreements, and then move forward. So anyway, that all went down. They let me out on bond. I had to stay there. It cost me a ton of money. I then served them all my documents. I don't go crazy with stuff. I send them. I have a specific record that I create on the public record. It's my power of attorney, declaration of status, attached exhibits, all that. Then I draft a specific notice and I send that to them, and I send them a copy of the birth certificate, and I go, here you go. Here's who you're talking about. You're now in custody. All right. So they have that. They're holding it. So I let that sit. Okay. Then I do my filings. The one thing that I've learned over the years is both sides of the fence. It's not enough to just know common law, equity, and all that stuff. It's very prudent to learn statutory law, procedure, court procedure, proper legal writing, that kind of stuff. Okay. Why is it important? Because they're going to railroad you at every turn. And if you have your administrative, statutory, court procedure, all that stuff in line, and you have the substance of the common law, equity, and all of that, you've got much, much better standing to go forward in this case, much better capacity, much better footing to go forward, right? This is what upsets me about a lot of the guys out there that teach this stuff. Like they try to get you to avoid court by handing these documents in, and usually it does nothing but makes it worse, especially, and which is all good in a civil situation. It's usually pretty easy, or traffic tickets. But when you're in a criminal or quasi-criminal situation, it's not so easy, because they want that bond, okay? They want that money. So they're not going to let it go so easily. So they had the hearing. They brought me back 3 weeks later in front of the magistrate. He clearly was scared to death. I don't know why. I've been kind to everybody, but he was shaking like a leaf when he was hand papers over the bench to the prosecutor. And he kept telling me that he's doing the best he can not to, what do you say, not to injure my rights or something like that. And I'm thinking to myself, dude, you're a judge. Like, doing the best you can, you should already know that. But he kept repeating it over and over, trying to be respectful of your rights, trying to be respectful of your rights, over and over. And I'm saying, man, you are just a mess up there behind that bench. What's going on? Kind the entire time, but quick, right? Innocent as a dove, wise as a serpent, constantly. So we went through that, and then they set my trial for the next year. Okay, which just happened my pre-trial conference just happened last week. My trial, quote unquote, is in June. Now, this all took place last June, okay? So I put my paperwork into the court, my judicial notice, having them take notice of all the laws I want them to take notice of, my motion to discharge under a specific statute that I found that if you don't bring me to trial within 180 days, you have to discharge. Another motion to have a video conference instead of me driving all the way out there, all that stuff. All shit that I know they're just going to run right over. And I want to say that on that point, I'm not worried about winning, and I'm not worried about losing. I could care less. What I am doing is building a record. I really don't care about the winning and losing, because I've got bigger plans that they're not. Maybe they are aware of by seeing me on the internet and talk about this a little bit. I don't know. I pretty much keep a lot of it private, but who knows? I don't care if they're aware or not. There's nothing they're going to be able to do to stop it. So I don't care about winning or losing. All right. I'm just building my administrative record constantly. So we went to the hearing last week, my pretrial conference, which, by the way, let me back up. On April 1st, they had a telephone conference with me so that we could hear this motion for video conference instead of having me drive all the way 700 miles for this 10-minute pretrial conference on this stupid misdemeanor. right? So we get on the phone, the judge denies me. No, sorry. She goes, I like to see people here in my courtroom personally. Oh, okay. All right, judge. Gotcha. Well, I'm going to put a minute entry in. You have 14 days to object. Okay, great. No problem. I got 14 days to object to the journal entry that where you basically denied me a video conference. Not a problem. So I let it go. 2 weeks goes by, almost less than 14 days. My hearing was on the 13th, right? So 14 days would have been the 15th for me to object on that particular issue. Again, this is all court process and procedure that if you don't understand what's going on, you're going to go in and argue the wrong points at the wrong time, because like some people go to a pretrial conference and they want to argue their charges. Well, that's not what a pretrial conference is for. Pretrial conference is to flesh out any issues that would keep the parties from going to trial. So my pretrial conference comes up. I bring witnesses with me. They come from all over the country to support me, which was fantastic. I'm forever grateful to them. 8 of them show up as witnesses, including my best friend, who's a 24-year litigating attorney that is a bulldog, and he's phenomenal at litigating. One of the best I've ever seen, one of the most humble men. You'd never know he was an attorney from meeting him, because he does not have that ego, and he does not look like an attorney, but he is badass. One of the most badass attorneys I've ever met. And clearly his firm knows that by the way that they take care of him. So he's there as a witness, and they know he's lurking in the background, because we've made it clear that that's my counsel. He's not my attorney, he's my counsel. And he's not here to represent me, he's here to counsel with me. We brought this up last year when I got arrested. He got on the phone and talked to them, so they know who he is. So we've got all kinds of little things going on in the background with these guys. So anyway, they finally have the hearing. We get there, and interestingly enough, the first case that they call is a woman that is from an area that's about 2 hours from me, and she's not there. Okay, her attorney's there. So wait a minute, you denied my video conference saying you want people there in your quote unquote courtroom personally, but here you're going to allow this woman who lives 2 hours from me to not show up because her attorney's there. And she knew it too, because she was like, to the attorney, she's like, I really would like her to be here personally. Same thing she said to me. And I knew, I'm like, she's saying this because she knows we just had this conference 2 weeks ago to handle this matter. So anyway, we get in there and they call my name. Again, calm, cool, collected. Am I nervous? Yeah, shit, yeah, I'm nervous. There's all kinds of stuff going through my brain. But, I relaxed myself enough to know that, wait a minute, we're just here for pre-trial conference, and I just need to ask the right questions. And we're going to go over my motion to discharge. So I get up there, I clear, first thing I do is always clear up who's who. Look, I'm not the defendant, so that's on the record, Name's Robert Michael House of Doe, whatever. I don't give my last name out in interviews and stuff, which is why I use Doe. But Robert Michael House of Doe, General Executor for the defendant's estate. Make sure that's on the record. Yes, it is. Thank you. Let's proceed forward. So again, yeah, this is all contract. I get it, because I know there's some people, oh, you're just contracting with that. Well, of course I am. But I've reserved all my rights constantly, and I continue to do so. Once I pull the contract out on them, yeah, it's going to be hefty, because they're going to pay my fees under this contract. First, we have to establish who they are. So we get into the motion to discharge. And of course, I'm going to deny that because under special administrative rules, and you'll love how this came back around to bite her. Okay, special administrative rules due to COVID. The 180-day speedy trial is not in effect. Essentially, we've suspended the Constitution, your right to speedy trial, because of COVID. Oh, great. Now you're admitting, plain as day, that the Constitution doesn't have effect in times of emergency. Awesome. Now let's go back through congressional records and see how many emergencies have been declared and not recalled since 1860, since you just admitted the Constitution doesn't have effect during emergency. Thank you for proving that point. Next. Again, she doesn't need to know this. I don't need to bring this to her attention. This is all being documented in the transcripts, by the witnesses, my own mind, taking notes. right? Prosecutor's like a bumbling idiot. The guy doesn't know anything. He's just, well, Your Honor, according to statute, blah, 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 he's whatever. So they go through that, right? She denies my motion. Great. Any other issues? I said, yeah, I'd like to know about the bond. Where's the bond sit right now? Well, it's at the clerk's office. Oh, it is? Okay. And what are you going to do with that bond? Well, sir, you see, the way it works is if we convict you, you forfeit the bond. If you're not convicted, then you get the money back. If you have a surety, that's between you and the surety. Okay, great. So now what did she just do? She just gave me the court's motivation for convicting me. Did she not? If we convict you, you forfeit the bond. Thank you. You just gave me your motivation. Got it. Okay. Now, remember, she denied my motion to discharge for a speedy trial, saying that I don't have a right to speedy trial under statutory this or that. So I said, I just need you, before we proceed to trial, I don't know how we can go to trial because, first off, there's no crime. And I said, there can't be a crime without an injured party. I said, so can you explain to me who the injured party is? She goes, well, the state of Kansas. I said, oh, really? And exactly how are they injured? Well, according to the complaint, they're injured. No, I didn't ask you according to the complaint. I asked you, what is the injury? How are they injured? Well, I'm not going to answer that today. What do you mean you're not going to answer that today? You're here to clarify so we can go to trial to make sure things are clear, right? So just constantly catching her in shit that she has no idea about law. And I even told her at one point, I was talking about the bond, and I said, that's a contract between me and the state. And again, she goes, that's not a contract, sir. I said, ma'am, I have no idea what law school you've been to, but you should probably get a refund because a contract is a bond, okay? We can go right in the law book and read. The first thing they say about a bond is it's a contract, period. And she was all beside herself, of course, right? So we're going round and round, trying to get her to clarify. I said, well, I've got, and I had printed out the Dun & Bradstreet profile. I said, I got profile of the state of Kansas that says they're doing business as. So it's my understanding if they're doing business as the state of Kansas, which I have another profile that says the judiciary is a branch of them doing business as. It's clear. It says right here, doing business as. Number of sales, amount of sales, all that, it's all right here. So I need you to clarify, is the plaintiff proceeding as doing business as the state of Kansas, or are they in Article 4, Section 4, guaranteed Republican form of government? Well, I'm not clarifying that today. Well, I don't know how we're supposed to proceed because I don't know who I'm dealing with. You haven't clarified the status and capacity of the plaintiff, who you may be a branch of, which means the cards are stacked against me, so I don't have any real chance at any of this. And so I need you to clarify that. Well, I'm not clarifying that you can bring that up at trial. No, this is a pre-trial conference to flesh these issues out, and you clearly are refusing to do that. So at the end of these proceedings in this particular court, they have a journal entry that they give to the clerk, just like I was telling you the one on April 1st. So I said, okay, I got it. Oh, and then I said, so she says, do you have any more questions? And I said, well, give me a minute. I'm thinking about it. I'm thinking about if there's any more. So literally just like that. But remember, you're not under any time frame to answer anything. You can take a minute to think when you're in court. You don't have to jump because they said, hey, I need you to answer. Well, give me a second. All right. So that's what I did. Oh, you just give me a minute. Let me think about this. So yeah, actually, I do have another question. I said, this jury that you're putting together, they're all U.S. citizens, correct? Yes. United States federal citizens, correct? Yes. 14th Amendment United States federal citizens, correct? Yes. Okay, thank you. No more questions. I think we're good. So prosecutor brings over to me the journal entry, wants me to sign it, right? Wants me to sign off on it. Now remember, not only do I have a right to object, I got 14 days to object and all that. So I look at it and I go, yeah, no, I'm not signing that. Why not? I said, well, because you got on here that my motion is denied, but you don't have what statute she's citing to deny my motion. I think you need to put that in there. Now, we were at like 20 minutes at that point. We went into overtime, and she had just gotten done saying, well, we're going to wrap this up. I've got things to do, basically, right? It took her another 20 to 25 minutes to get on the internet and try to locate the statute she was telling me she was using to deny my motion. 20 to 25 minutes it took her to find this. And she still never cited the exact administrative, it was not a statute, it's administrative order, right, in an emergency. Meanwhile, one of my guys behind me, my witness, is texting me, and this is all recorded, by the way. We have the audio, but unfortunately, it's only available to House of Marcus members on our website because I don't want to put that out there. But anyway, but I'm giving you the play-by-play anyway. So anyway, it's hilarious because he's texting me all the administrative orders that he found, and he's not like a law guru or anything. This guy is like brand new to this stuff, but he literally found it within 5 minutes and had all the administrative orders that related to that subject on my text. She's still trying to search for like 25 minutes. She's spitting them off to the prosecutor. He's trying to write them down. He's got a thing of white out. He's whiting everything. I mean, the most unorganized, incompetent show of a court and a prosecutor and a judge or whatever that you can imagine. These people are so, they have no idea what law is. And I want to stop there and say, you know, for people that are putting in all this paperwork and you think that they understand what you're talking, I'm telling you, they do not. There's this big mystique out there and this big, you know, belief in the freedom community that, oh, they know. Oh, they know. No, they don't know. They're idiots. Some of them know some things, and I'll give you an example of that at this very hearing. But they don't know. They don't know what we know. They have no idea how law works. They only know corporate policy, right? So he's over there trying to write down what she's saying. He's using, well, he literally had to get up and ask her if he could go downstairs and get another sheet of paper because it was so boogered up and blotched up he had to start over. I mean, are you kidding me? You know? So he comes back up and, you know, he's finally writing everything down. And I'm just laughing. And 25 minutes goes by, it's dead silent. She's just click, 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 trying to figure everything out. So he finally, you know, he puts it back on my desk and I look at it and I'm like, VICOACTUS without prejudice on the signature line. Underneath where it says, you know, print your name. Same thing, right? Hand it back to him. He takes it, walks up to the bench, and I see him slide the first sheet off and look at the signature page, and he just does one of these, like, these sovereign citizens, right? Then he goes up to the bench. She looks at it, and she's perplexed, okay? Another 2 minutes goes by where she's just staring at it, like literally just not knowing what to do. And then she's like, okay, well, you know, we're going to file this with the clerk. You have 14 days to object. I'm like, you dumb. She doesn't even know what vicoactus means or the fact that I signed it without prejudice. She's going to put it into the record. Thank you. And that's what I mean by if you know what you're doing and you know what they're supposed to be doing, you're much better off. So it behooves you to study both sides. Someone told me that years ago before I got into my first arrest. And I was too arrogant to believe that. I believe that all I need is private stuff, right? And they can't touch me. I know private stuff. Wrong. So I made it a point over the next 9 years to study the hell out of both sides. And that is what I've done. So the whole thing, yes, they railroaded me. But you see, not only did I document it, so did the witnesses. And we've got so much of them just blatantly, you know, shitting on my substantive rights that they don't even know they're doing. This is going to be really good. Not only are they messing up procedurally, so when they mess up procedurally, that gives me a right to appeal, right? Which again, I'm not putting any stock in that, oh, I'm going to appeal and the appellate court's going to come save me and, you know, reverse it because they made a procedural mistake. Usually they like to fry guys like us, so I'm not putting any stock in that either. However, it is going to delay things longer, right? It is going to provide me a stronger record for other things. So that happened on the way out. of town. Let me give you the stage here, guys. This is a small Kansas podunk town that has one prosecutor who has to have a part-time solo gig as an attorney, private attorney, if you will, because there's not enough crime in this town. Okay, this is it. I'm dealing with the chief judge of like 5 counties here. Meanwhile, there's a guy sitting in the crowd that came in. Now, they emptied the courtroom. It was only our 8 people, me, and this one other guy who came in before my session started and left after my session ended. But before he left, one of our people was chatting it up with him and said, I don't know how he got in the conversation. But basically, the guy said, yeah, I'm a judge. I see this all the time. So there's another judge sitting in the audience observing what's going on. I'm a judge. I see this all the time. So you know what they're doing there. Again, think ahead. What are they doing? They're going to take that judge off the bench and put him in next time. He's watching to see what I know, how I'm doing, what I'm doing, what my moves are. It's just chess. But don't worry, because we've already got them 3 steps ahead. We already know where they're going in all circumstances. They can dismiss it, fine. They can charge me, fine. Doesn't matter. They're going to put this guy up there, fine. Doesn't matter. We already have a plan for all of that. So on the way out of town, I still had 2 days left to object to that first thing 2 weeks prior to the hearing, right? The first journal entry where she denied my motion. Well, at dinner that night, when I'm sitting around with the witnesses, because we always have fellowship with our people, we're sitting around at dinner, and one of the guys pulls up. He goes, hey, look at this. And it's an administrative order that says the judges are supposed to encourage video conferencing. Encourage it, not discourage it. So she went against her own administrative order to drag me 700 miles there. Perfect. At the hearing, she tried to get me to, when we were done, to go over and get the last minute order or journal entry so that they could finish business and sign off on it. I said, no, that's all right. I appreciate that, ma'am. I said, but I still have 2 days to object to it. Honestly, I didn't know if I was going to object or not. I was just busting her balls. I got 2 days. Let's just let the clock run out, right? I'm not going to finish your business today because you're eager to put this into your record so you can up the bond and all that stuff on the back end. No, we're going to take our time with this. So I got 2 more days. But when I woke the next morning after having that conversation at dinner and seeing that administrative order, I was like, oh, no, we're going to object to that one too, because that's going to just be a freaking thorn in her side. So on the way out of town, stopped at the court, asked the clerk, can I have a copy of the journal entry? I need to file an objection. Yes. If you understand what you're doing, you don't have to type fancy paperwork of it. You can handwrite shit on the fly. So that's what I did. I hand wrote the objection with my attorney buddy next to me. We were like, yeah, let's word this up, handwriting, really good. So we objected, right on the face of the journal entry, objection, but we wrote the objection, cited the administrative rule, and then had the clerk file it and make sure we got a certified copy of the file so we knew that it was actually a filed objection. The clerk didn't object to that. She didn't go, oh, you can't really write that on this piece of paper. No, she knows damn well that she has to record anything into the record that I put in as an objection, whether it's written on toilet paper or not. So we did that. Now, so my trial is set, okay, for June 2nd and 3rd. The reason I'm saying all of this is because we have a plan. We've had a plan. I had a plan in my mind from the day I got pulled over. A lot of times what I see happen in the community is people just throw a bunch of shit in there. There's no plan. There's no well-written product of, how you're going to formulate your argument. There's no pre-work done. It's like, oh, I'm in trouble now. Let me throw a bunch of shit in there and you can't touch me because I'm a free man on the land and blah, 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 blah. And it doesn't work that way, especially in a criminal situation. They're just going to look at that and look at you as a sovereign citizen and just throw that stuff right out the door. So the bigger plan for us is unfolding. And it involves us suing them. And I think that's also a lot of what's not being taught in the community is how to go in and actually sue them. My standpoint on that is you have to prove whether you're acting in a corporate capacity according to your Dun & Bradstreet as evidence, or in a constitutional capacity according to your properly filed oaths of office, which they don't have 9 out of 10 times. Every great once in a while you'll get one that tries to pull the wool over your eyes with a recording of an oath, but it's not properly written and it's not properly recorded. So they'll try to pull the wool over your eyes. But other than that, there's no oaths. You can't have oaths. So the issue becomes your organization operating as a private, profiteer stepped out of bounds ultra vires, which means outside your authority. You're acting outside your authority. You damaged and injured me. I don't even know what the bill is at this point for how much I've had to spend to come back to live in Kansas for 3 weeks, come back there, get hotels, travel, food, all that, not to mention the damages and injuries to my person and my substantive rights, not to mention my fees in my fee schedule. Now, where are you going to take that? You're going to take that to federal court, because the feds like to beat up on the state and the state likes to beat up on the feds. They don't have a great relationship. So this is all for a bigger purpose. Not only that, okay, but what we're doing in documenting this stuff, when we get to federal court, we're fleshing out the name issue, the all caps thing. Now, there's a lot of people out there that talk about capitis diminutia, minima, maxima, media. I don't go there. That's not enough to say that this is, this has any merit. To me, what's enough that has merit is the rules of English language. There's no rule of English language that says, oh, hold on 1 second, guys. My computer's going to die. I didn't realize it wasn't plugged in. All right. There's no rule of English language that says a word is spelled in all capital letters. So what is the rule of capital letters? Capitonym. Look up the law or the rule of a capitonym. Whenever a letter is changed to a capital, it changes the meaning of the word. To me, that's a lot more substantial than saying, well, I looked up capitis diminutia in the Black's Law Dictionary, which says nothing about language as a rule, right? This strictly pertains to language as a rule. Then we also have the rules of homonym, homophone, homograph, homoglyph, okay? Homonym says there can be two words that look exactly or similar or sound the same, but they're not. Okay, they can look similar. In other words, one can be capitalized, one isn't. They sound exactly the same, but they have different meanings. That's a big deal. Okay, we have the issue of jurisdiction. Are you functioning in a corporate capacity or in a constitutional capacity? Right. We've got the issue of everything being tied to a Social Security account. These are all things that are going to have to be admitted or denied in federal court, and then we're going to have to bring any proof that their denial is wrong. And we do that through excellent legal writing and briefing of rule of law and good legal writing. The other thing with that is we're not here to put this in the public. So our case does not go into federal court in the public. It gets sealed. Why does it get sealed for us? Because we have state secrets here. So it behooves the federal court to make sure it's sealed, because they're state secrets that cannot be let out into the public. Now, in my opinion, and in my partner's opinion, who has and is litigating in federal courts, and has litigated in state courts, federal courts, corporate law, family law, all kinds of law, because he's not afraid like these other attorneys to just stick to one thing because it's a cash cow. he goes wherever he needs to defend somebody because his heart is in it to defend someone, not to make money. Okay, so we know that they're going to be a lot more apt to work with us when we've covered their ass by sealing the case. Now, I know there's a lot of people out there that talk about exclusive equity and this and that and the other. I don't get into that. Okay. Do I believe that there's things going on like that? Yeah, 100%, totally. But you're talking to a bunch of idiots here. Okay. If you do things, in my opinion, in the way that they recognize them, and you speak the language that they speak, and you show them that you're not trying to be belligerent and turn this into a precedent that everyone can use, which we're not trying to do. We're only turning it into something that we can use, and then we can help our members use it privately. We're not going to put this out all over the internet just so we can make a buck and have people, you know, go out there and tout themselves as free when they're truly, honestly, most of the people I run into, you know, off the internet and stuff, they're not ready to be free, in my opinion. And that's, you know, that's up to them. That's not my choice. I mean, if you're not 100% responsible for yourself and your actions, you're not ready to be free, and you'll never be free, because freedom is in responsibility, in my opinion. So this is, again, a much bigger thing. Just like I said when I first got into the incident, I'm doing this to expand it. I've already gotten people out of you know, trouble, if you will, for driving with their own tags and all that. We've already experimented with that back in 2013, and you know, we had courts apologizing to us, giving us property back completely. You know, with a guy that didn't have had his own tags and had his own ID, and you know, didn't have a registration or insurance. We gave him a birth certificate bond for insurance. Like, we've already done that. That's old news to me, which is not a bad thing. But I started to realize that's all well and good, but how many times do you want to be pulled over and have to fight this? Or is there a way to truly take control of your legal person and function in the world behind that veil without the liability to it? And that's what we're doing. And that's what I do at the House of Marcus. Is like, look, you know, if you have a driver's license, that's not the end of the world. How are you managing your business with that license? You know? And the other thing is, are these guys ever going to admit that that's really a contract that you don't have to, you know, that you don't have to sign? And if you do sign it, what are the terms and conditions? And is it a contract? Yes or no? Because at least here in the States, all the MVAs and motor vehicles and all, they all say customers, customers, customers. I mean, hell, I got a speeding ticket not too long ago, looked on it, said business address of the court, business address, you're doing business. I mean, that's the crux of this thing. So I don't look at like, oh, you know, this case is going to go away in 60 days, 30 days, we're going to shut it down. No, no, no. I look at it as, we're going to drag this sumbitch out as long as we can, and we're going to get as much on the record as we possibly can, because it's going to serve a bigger purpose. And where we're going at the House of Marcus is a much higher level, in my opinion, of freedom than just a singular guy going, oh, I did my UCC and I did this and I did that and I'm free. I don't give a shit about the rest of you. Because to me, that's still not freedom. That's not freedom. The fact that you got to jump through all these hoops and do all this shit over and over again, it's not freedom. You know, that's just a better form of slavery. So the way that I've seen, and JD can attest to this because he's been with me for 9-10 years. We've known each other. That this is a divine thing, and our freedom is a divine thing, and it will be released to those who are ready for it at a certain time. The path that I've been on has unfolded over a 9-year period, and going now into a new, what I call a new cycle. After every series of 9, there's a new cycle, where it's going to take time. This stuff takes time. But at the House of Marcus, what we're doing is building a solid foundation. It took me 2 years to create a step 1. Okay. And I'm just now getting to step 2. That might take me another 2 years. I'm not in a rush. What I do know is that my step one, and well, actually, sorry, we're going to step three. My step one and step two is solid in the way that I use it, as far as I know, and as far as I am, have educated myself, and I educate our members at the House of Markets to do these steps, but I educate them to know what they're doing, because it doesn't matter if they fill my paper out. It doesn't matter. If they don't know what to do with it or how to continue with it, it's no good. And that's why education is the most important thing, that you continually educate yourself. Because if you're grabbing paper off the internet from some guru that promises you the world, and you get some little minuscule win, woohoo, and now you're like, I'm free, my status has changed, my this or that. Just wait until a criminal situation happens, and I guarantee you will see a whole different side of this. And in order to correct that and to get people real freedom, it's going to take a long time. I mean, we're talking about thousands of years of slavery. It's not just going to unwind over 1 year. And if you think about it, it's actually happening at light speed, because at least in 1776 in the United States of America, that was a huge leap in freedom. Even though it was immediately, in my opinion, it was immediately usurped from the start. But just the mindset of, we're going to have the balls to do this and to take that step. And now, 250 years later, we're oh yeah, we need to pick back up on that. That's light years, man. That is so fast in history and in time, and in real time, not man's time, in real universal. That's like, it's like a day. So it's happening, and it's happening fast. But if you're into instant gratification, it's never going to happen fast enough. So that's where we're at. That's what happened with my hearing. The next thing is on June 2nd or 3rd. We don't care if we win or lose. I don't care if I'm convicted or not. What we care about is going to the next step, because we have a plan. And if anything comes across in this, it is to have a plan. Have a plan. Plan out your strategy. Don't just throw shit in the hopper and think that it's going to magically release you. Some people do have some good stuff out there, and there are times when that magic release happens. I've done it, but not all the time. When do we get to the point where we're automatically recognized and left alone? When do we get to the point where they see what we've done and they go, okay, you're one of them. Have a nice day. That's coming. That's coming. It's just going to take time.
There's a couple things I wanted to point out. I find it interesting that you had a judge in your gallery.
Yeah.
Because I had an arraignment hearing where there was this guy, and I was like the second one called up, and my questions led the judge to go, well, this is going to take a while, so I'll stand you down and deal with other issues first. That's fine. I understand. So we sat and we went through lunch, and we came back after lunch, and the court slowly got cleared, and there was just this one other guy left in the courtroom, and the prosecutor's looking at me and looking at this guy and going, well, I guess we're next. Nobody knew who he was. And as we were leaving the courtroom, guy's walking about 10 feet in front of me, and I yell out to him, so are you just interested party, or, he turns around and he says, I'm a judge on vacation from Cook County. And I thought, oh, interesting. First time I'd heard about a judge being in the gallery watching, and here's a U.S. judge, and I didn't know it at the time. I thought there was only one Cook County, but there's multiple Cook counties in the States. There's one in Arizona, there's one in Chicago, Illinois. There may be more, but to have him in there, and I said, so you got any advice from a lawyer? Yeah, I figured that was going to be your advice. So I find it interesting that you had a judge, because that's, I believe, what they do. They knew who I was because of what I'd done prior and what I was bringing to the table, and to have a judge in there, I believe, to give advice after the fact as to how to deal with it and to observe and report. I think it's definitely part of what's going on there. The other thing which I find interesting is, and it's a point you make, and I just want to reiterate again, is making a record. Like, most people want to make it go away as fast as possible. You have a
Right.
different objective. You have a longer term objective to create an evidentiary record so that you can then prosecute them, right?
Yes.
And
Yep.
so it's a whole different attitude, a whole different posture, and making the record, whether you have that as a long-term goal or whether you're just trying to make it go away, you need to make that record because that's going to be the way you make a complaint about them, make a claim against them, sue them, whatever. So making a record is absolutely key. It doesn't matter what you're doing. If when you're first pulled over, you want to make a record, take notes because those
Of
notes are
course.
admissible in court as a record of what happened, just like a
Yep.
police officer's notes on the scene. So yeah, huge. Understanding process, big time. If you're going to do anything, you need to understand what could happen and the process associated with it. Um, there's a fellow from years back, George Gordon. Have you ever heard of him? He
Hmm.
passed. He probably
No.
passed away. He was an elderly guy. He probably passed away maybe 8 years ago or so now. But he's an old timer. He'd been doing this since the 70s and teaching law down in the States. And then he had a guy who got arrested, put in jail, and he had this program where he helped people sue Title 42 lawsuits.
Oh,
And
I have heard about this guy. Yeah.
he paid this guy to stay in jail longer. He says, I'll pay you a monthly salary to stay in there. You collect all the evidence of all the rules they're breaking, and we're just going to lay suits. And the jail ended up having the insurance company raise their insurance rates
Yeah.
multiple times to the point where they basically couldn't afford insurance anymore. So when you sue them, you put at risk their insurance and their bonds.
Yep.
And a couple of suits against them, they could lose their insurance. So filing a complaint against them is powerful. Suing them, actually, no matter what happens, just the fact there's been a suit is going to cause them problems with their insurer.
Totally.
So yeah, so you know what, sue wrongdoers is my other website, teaching people yes you can sue and yes you should sue. So
Yes, absolutely.
yeah,
And speaking on
so
that, the insurance, one of the first things, I'm glad you said that. One of the first things that we did when I was in jail for that, 48 hours was I had my girlfriend go over to the clerk and get the county's bond information. And they handed it right to her. They're only insured up to $5,000. So
was that the bond on the case or some other bond?
no, bond on the county. Their indemnity bond, their operating bond, right? So we're going
Yeah,
after.
that's going to hurt them.
That's going to
And
hurt
then they
big
said
time.
with the state secrets thing, that was one of my concerns when going through the process. I was putting so much stuff on the table in terms of exposing the fraud of what they were doing. I thought that they would use some technical out to let me go because they didn't want to see it in a trial, right?
Right.
I thought they would flush it. In this particular case, they didn't. But I'm curious, um, how will you deal with that, or do you have any idea how to deal with that if they try and flush it on some sort of technicality um, because they don't want it out? Because this is part of the thing is they're going to do what they can to prevent stuff becoming recognized on the record, right?
Right. So I look at it as if you put that stuff into the record and you go on those merits, they are going to shut it down because if they were to ever set a precedent in that way, um, now you have all this proof, which is why going into federal court, we want to say, hey, we're going to seal this because we don't want, because when you seal it, it's not out open in the public and it doesn't become a precedent, which is why we want to seal it because we want to let them know, look, we're not trying to put this out in the public. Yeah, we did it in this little case here. We were trying to let them know subtly, like I didn't get into the straw man name and all that. I just said, here's my evidence, leave me alone kind of thing, right? Let's drop it. And they wouldn't do it. So now I got to go to federal court and we need to seal this. So it's actually sealing it so that they don't throw it out because now it's protected. Now nobody in the public can go in and see what's in there. They can't
Right.
see the evidence.
Okay.
So I feel like we'll get further that way than trying to sue in federal court and bring this stuff up.
Now, I've tried to seal a case in the past as well, and either party can apply, make an application to have the case sealed. And they have to give the reasons why they want to seal it, and then the judge goes, "I agree it should be sealed," or "No, I don't believe it should be sealed."
Right.
So you would be making the application, so you're being proactive about it. You're going to basically expose the fact that they're state secrets, and you don't want to hurt the state, and that's going to be the basic position as to why you're seeking it to be sealed. Is that the idea?
So far, yeah, but Jude and I have to flesh that out.
Okay.
Remember, he will his mastery in process and procedure mixed with my substance. Sometimes we get to the point where we're ready to make the move, or well, we're fleshing out what are we going to do to make this move, and we see a better way. So right now, yes, that's where it stands. It might change, is my point.
Okay.
But
So
we will find a rock solid, because Jude's one of these guys. He does not do something unless he knows this is a way that they cannot deny us.
yeah.
So it might change, like I said.
Okay. So basically, the trial date is set for June of this year or next year?
No, June of this year.
Okay.
Everything happened June of last year. They set it for June of this year, second and
Okay.
third.
So are you planning on the federal suit after the trial or before the trial?
Yeah, well, here's how. So first we got our motions coming. So we got to flesh out a brief. Actually, it's going to be a bunch of briefs combined, okay, to flesh out our our stance on this thing, right? Motion to dismiss for jurisdiction, right? Again, we're just putting this in because we know that they're probably going to deny it and still move forward to trial. So when we get to trial, a motion on jurisdiction, they have to stop everything and handle that motion. So I'm not sure if they're going to have a separate hearing for that, or if they're just going to go, no, we'll wait till the trial date. Oh, well, we're denying your motion. Let's move to trial, right? Which is how they operate. So our plan is, yes, we have some things to throw in there to kind of, throw a little wrench in there and build our record. As it stands, June 2nd, 3rd, and that it should be over after that. And then we go into appeal. Then we do the appeal, however long that lasts, and then we go into federal after that.
What if they drop the charges before the trial date?
Even better, right to federal.
Okay.
Now we're suing you.
Just a fun little note on the wait for trial. Personal experience with this, watching in other cases. I've sat in the gallery watching a lot of cases, and it's a favorite ploy for the judge to say, well, wait for that to trial, wait for that. We hear that at trial. We're not going to hear that now. Wait to trial. And then the judge at trial goes, what? You should have done this before trial. It's too late. So
right.
It's like, excuse me?
Exactly. And see, that's why building the record is so important. Getting the transcript, seeing what she said had to wait till trial, right?
Yep.
Because now we go, no. She said this had to wait till trial.
Yeah. Yeah.
So the record's important.
Games. And the other thing you talked about was it takes time for this entire process. Most people come to the legal process or the law process or the freedom process with a sense of urgency because they have something attacking them right now. And a lot of them are looking for that fast solution. Just fix it, make it go away, make the hurt stop, save my house or whatever it happens to be. First of all, it takes more time to prepare for that in all ways. And as far as the overall process of reclaiming freedom that's been slowly taken away, it takes time to change the system. What you're doing is you're re-educating people inside the system about all the things they're doing wrong, having to hold them accountable for it before they clean up their act. So that all takes time, and recognizing the fact that a year or two is nothing. 4 or 5 years is almost nothing. These things take a decade at least to filter through the system. And the other thing that they do is they watch what we're doing, what we're bringing into court, and they rewrite the law in order to hide the things that we've exposed. There's 2 cases here I've had personal experience with. They rewrote a section of the criminal code that one group was teaching, and they didn't take it out. They just redrafted it so it was less clear, it was more obscure. It said the same thing if you knew how to read it, but it wasn't as precise.
Right.
And people go, oh, they denied our rights, they've taken our rights away. No, 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 no. They just made it harder for you to see it clearly. And another one was the Bank Act. They actually deleted the section, moved it to another section, renumbered it, redrafted it, and created a second bank account with a different name to create a bait and switch on 2 different accounts, because we were teaching accessing a private bank account through the Bank Act. But that took 3 to 5 years before it was first before them, and then having to go and redraft statute in order to, everything's still there. Your rights are still there, but they've changed it.
Yep.
So they're modifying as you go along and hiding stuff when we bring it up. So I really like the idea that you're trying to set a process and a precedent for the basic principles, which is big on my goal for all of this stuff. There are fixed things the system does in terms of an abusive process over and over and over, and there should be a fixed way that we can deal with it in order to make them stop doing it, because they're getting called on it and beaten with it over and over and over again. We shouldn't have to reinvent the wheel all the time. So I'm excited if you follow through with that sort of stuff as part of what you're doing.
Oh yeah, we totally will, man. I mean, that's what we're doing. And you know, if you think about it, it's funny as a carpenter, man, and working for different builders and stuff over the years as a subcontractor, they used to say, oh, you want that subcontractor to do it right? Hit them in the wallet, hit them in the wallet. Well, it's the same thing. You got to hit them in the wallet, because that's all these guys are after is money. They don't give a shit about anybody's life. They just want to rack up that money on the back end so everybody can get their hand in the cookie jar. So cool. Let's take that out of your wallet then.
Yeah,
you know?
the only power we have is public exposure of what they're doing wrong, which is hard to get publicly. The next thing is attacking their individual bonds so they could lose their job by
Yep.
filing complaints against them to the bar association and so on. Again, it doesn't matter if it goes anywhere; it hurts their bond.
Right.
And hopefully, and laying claims or charges and pursuing them in court, so you're suing them personally. And you said something earlier about the fact that if they're doing something outside their office, the powers of their office, that is the law considers that to have been not done by the official, because the official can only do what the official is allowed to do. If the official does something they can't do, it by law couldn't have been the official that did it. So it must have been the private individual. And so that's why you sue them in their private capacity when they go outside their office powers, because the officer could not have done it, because the officer is not allowed to. So it must have been the private person. That's how you make them privately liable for their actions. And you
Right.
sue them. They don't have protections of the office. They don't have like in our statutes up here, you'll always see a clause that says you can't sue, a judge for decisions from the bench, right?
Right.
That's all people read. But the second half of the sentence says, unless there's evidence of bad faith,
Right.
right? So there always has to be the ability to correct any officer because of evidence of bad faith. And so the first part, that's all they talk about. You can't sue him, you can't sue him, you can't sue him. Oh, just a second, what about the second part here? Unless there's evidence of bad faith. Well, if they knew you had rights and they infringed anyways, and you made a record of what they were doing, then that's evidence of bad faith. They acknowledged, they acted anyways, they're now outside the office, they're now personally liable. So yeah, it's all good stuff. And it's interesting to see you going down this route, because it is the only way to correct and soften how hard the system has gotten, is by going after their processes that they're abusing, and the way they're applying all of their corporate stuff to private people, and hold them accountable for it. So yeah, that's all good news to me. So I'm looking forward to hear what transpires down the road, and we'll get further updates from you.
That's true. So there's a video that we did with some of our witnesses before the hearing and after, so people could, get an idea of what my attitude was like, how I handled the court, what it was like being in there and seeing this stuff from people who are newbies and some people who have been at this for a while. So the video is just a, witness testimony type of thing of what took place that day.
Thank you very much for taking the time for giving us that update. I'm excited about the progress you're making with this and and where you're going with it. I look forward to hearing more about it.
Yeah, you're welcome. Thank you for having me on, brother.
All right, you take care, and everybody else have a great week. Talk to you soon.
Yeah, you take care too,
Bye-bye.
man. Talk to you soon.